Of course, coming short after the resumption of the commission, obviously to allow Ms. Ramsamy to be able then to testify. She is now back at the commission on the 14th of August. Give us a sense then in terms of what was, the main anchor of her testimony today.
Hello again, Unati. So we've adjourned for the day earlier than usual, about half an hour earlier than the usual 4 p.m. cutoff time for these Madlanga Commission hearings. That's because Fediel Ramsamy, the IDAC prosecutor, has been struggling with a cough from this morning, but it appeared to get worse from the afternoon. She wanted to persist nonetheless and continue and wrap up, in fact, her testimony at the Commission by the end of today. But the chairperson, retired Chief Justice, not retired Chief Justice, but retired Justice Mwiseli Madlanga, and the evidence leader, Advocate Sigels Ncube, agreeing that it would not be perhaps the best thing to do to continue with her evidence given just how much she was coughing in the latter part of the day. And it's interesting because it came at a time when the Commission was dealing with testimony related to IDAC and how it became involved in any sort of investigation into the Medicare 24 contract. It was a health services contract awarded irregularly to a company where people like Kat Matlala, the alleged criminal kingpin, listed among the owners. Mike van Wyk is also Kat Matlala's partner in those issues. We know that contract was eventually overturned. It would have brought in something well over the tune of 300 million rand had it been seen through. So let's bring in SABC News senior reporter Kenny Mapanga, who I'm hoping has better luck with her words today. Kenny, I've already redesignated the chair from his role in the bench and possibly other things here. So you're better with dates. So I'm hoping you'll help us out here in working out a timeline for the Medicare 24 evidence, especially when it comes to IDAC, because we're now at a point where it seems once again they may very well have gone beyond their mandate.
Yes, absolutely. I think it's better if we try to frame it in terms of themes instead of the timeline. And what continues to emerge, Tembegile, is that you see an investigation started. There's no legal factual basis or ground for it to be started. So, i.e. in this instance, that is the Medicare 24 case, there was no Section 27 referral. To clean up that issue, what then you'll see is them working backwards to solve the issue that they've created at the front of the matter, which is really at the heart of IDAC's conduct in the manner in which they did things, because you're seeing that there's an investigation that started before an authorization can even take place, and even before you even have a Section 27 referral that can give birth to such an authorization. So the Medicare 24 case is one of those instances where you're seeing that the complainant is also part and parcel of the investigation, and that as of, I think it was February, as Johnson contended in the ad hoc committee, there was actually no Section 27 referral. So how did she authorize the matter without or rather authorize an investigation without that Section 27 referral? So it's a consistent theme in terms of IDAC, and it speaks to the overall narrative or allegation that this was about getting people in that accused box, or certain targets allegedly in the accused box, by any means necessary, even if it meant working backwards, which is not how things are supposed to be done, in order to secure a person in the accused box.
So just on working backwards, I mean, the suggestion from Ms. Ramsamy's evidence is that it was a bit more than that, and that there may have been, in fact, an attempt to rig the timeline, which I was referring to make sure that the evidence presented here and in Parliament suited the way in which IDAC took steps.
Well, that's how the theme works or runs concurrently here in all of the cases that they dealt with, is that it seems that allegedly there's a conclusion first, and then you work up to that conclusion. And that's not how the investigation is envisaged in terms of the guidelines to IDAC. It's you start with the Section 27 referral, you establish whether or not there are any grounds to permit you to then elevate it to a Section 28(1) authorization. That's when the prelim investigation comes about in order to secure whether or not there's a prima facie case here. But it seems that in terms of the crime intelligence matters, because that's really what we're focused on, the conclusion is reached first before you even do the investigation. And if you look earlier into the evidence, when you look at the Mukwele matter, it seems that when questions were now mounting from Hlatshwayo and Ramsamy about the merits of the matter, here comes the name of Police Minister Senzo Mchunu again, where Paramount then refers to a IGI report that is not complete, so therefore shouldn't have been released at that time to IDAC. And that report was given to them by Police Minister Senzo Mchunu. And seemingly the inference there was that it was to bolster that particular matter. And we hear, or rather see through the evidence of Sorunya's correspondence, that he said that this IGI report doesn't even take the matter further from where they stand right now and the concerns that they had regarding the Mukwele matter. So it's concurrent themes. Johnson's untruths continue to emerge. The methods continue to be raised before the Madlanga Commission, and it seems that things are done backwards in order to allegedly serve interest. So you know at the outset that you didn't meet the requirements, but to clean it up, you then find yourself doing Section 27 referrals and authorizations after the fact. Even worse with the Section 28 authorizations of the Mukwele matter, we see that those only came in July, and we know that they were appearing in court in June and were arrested in June. So it's yet again this consistent theme of things being done after the fact to justify the alleged unlawful conduct that precedes it. And that's really what's being highlighted through the evidence of Ramsamy.
It still begs the question, doesn't it, Kenny, of whose interests would have that been meant to serve? Why not do things? If there's a legitimate issue to be investigated, why not follow proper procedure?
Well, there's always a hint that Ramsamy gives, but she doesn't want to go into great details about whether or not there was any pillow talk with respect to what was motivating Johnson's alleged interest in crime intelligence. But there is Mr. Junaid Johnson, who has been mentioned, who is the husband of Advocate Andrea Johnson. There's Major General Faraz Khan, who features quite prominently in these matters, even to the extent that Johnson mentioned that there was the person who was acting in General Khan's place was someone that they needed to get something on as well. So there was a deep interest in preserving the status quo within crime intelligence, and it seems that IDAC was going to play an alleged role there. And in terms of the Medicare 24/4 case and the kind of alleged targets or the alleged intention, I think the answers there can be found in Police Minister Senzo Mchunu, because he seems to have had an interest in some of those investigations, even going to the extent of giving an IGI report to the investigator. I mean, that alone shows that there was some interest in trying to see these particular officers prosecuted. The question is why and to what end? And I think the Commission will continue to warm up to that particular answer as the IDAC evidence is set to advance over the next few days, with Fediel Adams, who really is at the center of the first case that gives rise to all this controversy, expected to return on the 19th of August.
And let's talk about Fediel Adams. Today was supposed to have been his date with the Madlanga Commission of Inquiry. We got word, in fact, about, I think, 2-3 hours before that was going to happen, that ultimately the affidavit and other annexures that he was expected to submit to the Commission had only come in at about after 9 p.m. last night on Sunday, and therefore we could not continue today. And his explanation for that, it's fair to say, was quite underwhelming, especially for the commissioners.
Well, it was quite obvious that when he didn't meet his Thursday deadline that the process would not follow, and of course the Commission will not be able to proceed with that evidence, because we do know that the Commission's bench does actually read the statement before and gets quite familiar with it before it's presented before the Commission. Also, the evidence leaders need to go through it in order to prepare their line of questioning. There's no way you can do that after 9 p.m. But the excuse he gives is quite strange, because we've seen Fediel Adams, giving commentary, appearing in multiple different court cases with different questionable individuals, or allegedly questionable individuals. However, from October last year until now, he was not able to complete that statement in terms of the Rule 3 notice up until last night, the 11th hour. So, of course, the Commission's bench was not pleased with that particular discovery, even making it known that from now on he is to take the Commission seriously when they make certain requests of him. So we do expect on the 19th for him to return, and he must explain not only why he was in possession of those classified documents, but also why there was that small gap between when he had it and when he opened the cases, what is his alleged role in all of this, and how then does this scant statement that is projected before the Madlanga Commission, which one belongs to him? Is it the one with the PKTT, where he makes allegations there, or is it the other one which is alleged to be manufactured and brought to the Madlanga Commission in a bid to allegedly mislead the probe? And if that indeed was the case, then one wonders which matter or which referral was used to take the matter to court, and then of course it raises serious questions of alleged impropriety, and then of course questions of legality surrounding the investigation into the Mukwele matter at the very least. So it all starts with that Section 27 referral of Fediel Adams, and he will have to come and explain that on the 19th of August.
Kenny, thank you very much. Listen, it's a cold day in Gauteng, but it's